I do submit here again, now that I have the chance, that this independence, broad and pure as it may be, must only be restricted to 4 areas. 1, decisional independence, which allows every individual judge and every judicial officer to determine the outcome of a matter before them based on the facts, the law, the evidence. There is no negotiation about decisional independence. That one is pure and it is complete. Similarly, this, my understanding of judicial independence, other than decisional independence, it is administrative independence to administer yourselves, the Chief Justice, the Deputy Chief Justice, the Chief Registrar, the presidents of the various courts, and to carry out your administrative, you administer the institution without interference. Thirdly, operational independence, to carry out your operations without interference. And finally, financial autonomy, which is what we are discussing here, how we can perfect that. Anything beyond those 4 legs, decisional independence, financial independence, administrative independence, and operational independence, you must submit to other arms of government and other agencies for a democracy to work. That is my submission, and I could be persuaded otherwise, but not today. The second reflection is on the clarity that we aspire for around our very progressive constitution. My understanding, and here I want to admit I could be wrong, is that the jurisprudence I've seen so far since this very progressive constitution came to place somehow equates the entire constitutional framework and treats it as a set of norms of equal status. So you interpret the Constitution from cover to cover and assume anything and everything provided, all the norms enshrined in that Constitution enjoy equal constitutional status because those are provisions of the Constitution. With tremendous respect, I hold the view that there is a hierarchy of norms in our Constitution. We have a hierarchy of norms in the Constitution. Some constitutional provisions are superior to the others. That is why, for example, by way of example, that is why if you wanted to amend the Constitution, parts of the Constitution can be amended by Parliament, and the matter ends there. But if you touch other norms, you have to go back and conduct a referendum. That already creates a hierarchy of norms in the Constitution. If you touch this one, you go back and do a referendum. The others, you can amend. That is just one example of the hierarchy of constitutional norms. The same document, same constitution, but it creates a staircase of norms. With great respect, I argue that provisions like those in Article 4, Article 5, Article 10, and Article 238 of the Constitution are primordial and entrenched. national interest issues which cannot be varied even by the judiciary. If the judiciary attempts to vary those primordial and existential norms, the judiciary runs in confrontation with the people. So the same way some norms are superior is the same way they should be interpreted with care. With care, and I dare say with great care. Because if it is, for example, constitutional amendment, you cannot, for example, amend Article 4, which says Kenya is a multi-party democratic state. If you want to amend that article, you must go to the people for them to decide we are no longer a democracy, we are a dictatorship. So the same way that provision is given that superiority, and there are many others, it's the same way the interpretation of those norms must be very, very carefully handled. And therefore, this hierarchy of norms, we need to see more of it. I brought in Article 238 because Article 238 has bits and pieces. If you read it with Article 10, you'll find bits and pieces of what the framers of the Constitution consider to be the core national interests that must be protected. The internal and external threats to the existence of Kenya are in Article 238. And I'm sorry here I'm a bit biased because in my journey of service to the nation, I have for 2 years been in charge of the national security of Kenya, and therefore I have a bit of bias there because Article 238 talks on what the national security agencies for both internal security and defense must protect from our sovereignty and the other elements in Article 238. The third and second last reflection is on our Bill of Rights. I want to commend our judiciary for doing a wonderful job in providing a good jurisprudence on our Bill of Rights. Going into the future, I want to respectively suggest that the judiciary should help us to unbundle the Bill of Rights beyond the political and civil rights, because that's where we have concentrated on. I see my Lord here, the Deputy Chief Justice of South Africa. I have a lot of admiration for the legal system and the judiciary of independent South Africa. And again, let me first of all declare a conflict of interest. Part of my education, part of my modest education was acquired in your great country. But having said that, having declared interest, there's nothing wrong with conflict of interest so long as you declare it and also assure that it will not interfere with the decisions you make. Now, our country has done so well in providing very robust interpretation of the Bill of Rights, but unfortunately until now, we have concentrated on unbundling civil and political rights, which are the first generation rights. Yet the Constitution of Kenya places at the center of the Bill of Rights socio-economic rights. The reason I mentioned South Africa is because the South African Constitutional Court has given us great jurisprudence on many issues, starting with the right to life issues in the South Africa versus Makwanyane case in 1995, the first landmark decision of that Constitutional Court. But on the question of socio-economic rights, the famous case of South Africa versus Subramani, the man who had chronic kidney failure and was confronted with a denial for treatment in a South African hospital, yet the Constitution of South Africa, just like the Constitution of Kenya today, had a provision saying, very, very clear words, very accurate but very brief and clear words, that no one may be denied emergency medical treatment. And you know, when the lawyers for Mr. Subramani, who was dying out of kidney failure and was denied emergency medical kidney dialysis treatment, went to court, unfortunately, the South African court found against him. But they gave us very good jurisprudence about socio-economic rights, especially the right to health. Mr. Subramani lost the case. The Constitutional Court gave the decision a day like today. The following day, Subramani died. And many people in South Africa started asking, so what is the business of this Article 27? If the Constitution says you cannot be denied emergency medical treatment, and then the court tells us that this is not enforceable, so what is that article doing in the Constitution? Okay? What is that article doing saying you have a right? So later on, the court redeemed itself, the South African court redeemed itself by clarifying the parameters of enforcing socio-economic rights. Progressive realization, some of the rights have internal qualifiers, it's just access to the right as opposed to absolute right. But at least there was progress on other things around housing, medical, and other socio-economic rights. You have a challenge, the judiciary of Kenya, to interpret Article 43 of the Constitution. It cannot be muted. You must tell us what those rights in Article 43 mean for Kenyans. And this administration has been very focused. If you look at the manifesto of this administration, very focused on realization not just of civil and political rights, the first generation rights, but helping our country also progressively, subject to available resources, realize the socio-economic rights that are in the Constitution. So, those are my reflections today. I have many others. I've been looking for a chance, which I rarely get, because the kind of things that I do these days are quite opposite of, there is very little reflection in the things that I do.